Welcome to The Explainer. Okay, today we are diving into something really interesting. It's not just a court case, it's this extraordinary legal document from a high-stakes foreclosure case. And believe me, this thing turned a pretty standard legal fight into an all-out war of words.
All right, so let's get right into it. The story here is about a guy who was representing himself in court. And he basically decided, you know what? If I'm going to fight this corporate giant, I'm not playing by their rules. I'm going to write my own.
I mean, you've heard this story a million times, right? It's the lone individual going up against some massive corporation with a whole team of lawyers. A total David versus Goliath situation. But here's the twist. The slingshot in this story? It was a sworn affidavit. And the stones? Well, they were some incredibly sharp words.
So instead of getting bogged down arguing the nitty-gritty of foreclosure law, this guy boss, he does something pretty radical. He decides to go after the conduct of the lawyer suing him. He completely shifts the focus from the case itself to the ethics of his opponent.
And you see his strategy right from the get-go. I mean, the very first sentence. Bass isn't treating this like some dry legal dispute over a house. No way. He frames the whole thing as an ethical battleground. He's basically putting the other lawyer's professionalism on trial right then and there. Okay, so let's really dig into the strategy here, because these provocative claims were incredibly sophisticated. I mean, this was not just some angry guy ranting. Every single word was a carefully calculated move.
You know, Bass was just incredibly smart about the language he used. He started throwing around terms like sporting conduct and ethical duty, phrases that any judge would immediately recognize. He was speaking their language. So he wasn't just complaining, you see. He was tapping into these long-standing principles of legal fairness and what a lawyer is supposed to do.
And this is just a brilliant example of his strategy in action. He wasn't making these vague, wild claims. He was subtly pointing a finger at a specific professional rule that the other lawyer was, in his view, breaking. And it's a rule that's on the books specifically to protect people just like him, people without a lawyer. But then he takes it a step further. He starts suggesting that the lawyer's aggressive tactics, they aren't a sign of strength or confidence at all. He frames it as a cover for, get this, professional insecurity and incompetence. It's a total psychological jab. What he's basically saying to the court is, look, a truly skilled, truly confident lawyer, they wouldn't need to pull these cheap tricks on someone who doesn't even have legal training. He's trying to flip that power dynamic completely on its head. And then he does something really high risk. He throws out this masculinity challenge. It's a super bold, almost old-fashioned kind of move that taps into these ancient traditions of courtroom honor. He's questioning his opponent's character on a deeply personal level. Okay, this next part is probably the most explosive claim in the whole document. He flat out calls the lawyer's actions criminal. I mean, that is a massive accusation. But here's the genius part. It's a calculated gamble. He never actually says what crime was committed. That little detail is what protects him from getting sued for defamation, all while landing this incredibly powerful punch. So you see what he's doing, right? The key thing here is he's building a narrative. He's not just on the attack. He's carefully crafting this image of himself as the honest, courageous guy who's willing to say things directly. And at the same time, he's painting his opponent as a coward who has to hide behind these sneaky implications. So this all begs a huge question, right? How on earth did he make all these inflammatory claims and not get immediately slapped down by the court? Well, the answer, it's all in the precision. It turns out he was following this very precise set of, let's call them, unwritten rules. He used careful language, words like seems to or perhaps. He made sure to attack the lawyer's actions, not his entire character. He grounded everything he said in the official case record. And, crucially, he did it all inside a formal sworn affidavit, a legally protected space. And let me tell you, legal experts who looked at this document, they were stunned. They saw this wasn't just some emotional rant. It was a precisely navigated rhetorical assault. I mean, it showed a level of strategic thinking that you just almost never see from someone representing themselves. But what's really fascinating here is what he didn't say out loud. He used such careful phrasing that he was able to lead any legally savvy reader, like the judge, to draw some very serious conclusions about professional misconduct, things like barratry or abusive process. But he never actually made those specific allegations himself. It's brilliant. Okay, so after all that, all this strategic, explosive language, this incredible legal tightrope walk, the million-dollar question is, did it actually work?
I mean, you'd think a document this fiery and this carefully put together would get a detailed response, wouldn't you? You'd expect a hearing, maybe, or at the very least, a thoughtful, written analysis of his claims.
Yeah, that's not what happened. Not even close. The court's entire response to this rhetorical bombshell was this one single dismissive footnote at the bottom of an order. That's it. A complete and total shutdown. But that little footnote, it sent some pretty powerful unspoken messages. It basically said, 1, you filed this the wrong way. 2, we don't like to publicly criticize lawyers. 3, we don't believe you anyway. And 4, you should probably not try this again. And this right here is where the story blows up and becomes about way more than just one guy in one case. That single footnote, believe it or not, points to a much bigger and honestly more troubling issue in our whole legal system. So when you step back and look at the strategy, yeah, there were potential benefits. I mean, he created a really vivid record he could use for an appeal, but it came with some huge costs. He definitely risked alienating the judge, and he might have even distracted from the main legal points of his case. It just highlights the impossible situation people without lawyers find themselves in. This case is the perfect illustration of that terrible choice. When you don't have access to the proper channels to complain about misconduct, what are your options? You can either stay silent and let yourself be exploited, or you can speak up in the only way you know how and risk getting shut down or worse, punished by the court. And that right there is what experts call a systemic blind spot. Now, the Idaho Supreme Court is eventually going to have the final say on this specific case. But the question that this one affidavit raises, it's so much bigger than that. It's a question that affects vulnerable people trying to navigate the courts everywhere. And it really makes you wonder about the core idea of fairness in a system that was, let's face it, built by professionals for professionals.